Ramakrishna garu start చేద్దాం.
Yes.
Yeah. Good evening to all. Welcome Goutam ji and Vrunda ji to Mana Manchi Pusthakam YouTube channel. This channel has been introducing books of contemporary Indian importance, and both from history to philosophy to politics, and occasionally books related to law. This is one of such an important occasion, and we have been bringing works like this for last 2.5 years, and we have been reaching out the people about 5 lakh viewers till now, and we introduced more than 100 titles, both mostly in English, and some of them are in Telugu. So this is the basic introduction of our channel. Thanks to both of you for accepting my request on behalf of Manchi Pusthakam. We are living in interesting times, particularly for last 10 years. There's a lot of changes that were making a humongous impact, particularly in the legal field. The rights perspective is completely under severe attack, both from the state and also the institutions of the state. At such a time, most of the people aggrieved by the actions of the state are looking towards the judiciary for solace, for relief. So in that context, I found it is an important book to introduce, bring to the notice of the people, so that few of concerned people, citizens, can have a look at the contents of the book. And I have been following Goutam's blog, because I am one of the subscribers, so I used to get continuous updates from the blog. So some of the blog postings, without permission from the Goutam, being a former journalist, I used to translate and publish in Telugu in various platforms, including my Telugu website. So this is the idea for taking up this book at this time. I request Professor Ramakrishna Prasad garu, who is a professor from Salgaonkar Law College, Goa, to preside over the session. And a brief introduction to my viewers. Of course, you both of you are not required any introduction, but as a brief introduction to my viewers. Goutam Bhatia, author of the book, has been a versatile blogger, because he started just writing, so I can't say versatile writer. He is into both fiction and non-fiction, primarily in the non-fiction field of law. Has worked as a law clerk from Delhi High Court, and then moved to Delhi Supreme Court. He is now practicing in Supreme Court. And this is one important contribution from my understanding to demystify the happenings in judiciary, and particularly the apex court level. Because we used to go through the newspapers and find, oh, this is what so and so judge has commented upon. Oh, this is what so and so judge has reacted upon to a presentation by the counsel. But at the end of the day, all those intermittent interactive phrases or comments or running commentary won't be part of the final judgment. That lapse will be there. So Goutam Bhatia is trying to explain to some extent what exactly happens while drafting a judgment and while it is coming out to the public. And Vrunda Groverji, she has her own legal standing as a rights activist from Soni Sori case of 1987 to till now. She is noted human rights activist, and now recently I came to know that she has been appointed as United Nations Human Rights Council representative on Ukraine. Thank you, Vrundaji, and thank you, Goutam. Mr. Prasad, you can take over from now. Mr. Prasad, yeah.
Yes. Thank you, Veeray garu, and good evening to the viewers of Telugu Adda Manchi Pusthakam. I am very happy to be part of today's talk. First, let me congratulate Telugu Adda for selecting such an important book to discuss today, that is Unsealed Covers, A Decade of Constitution, the Courts and the State. As a presiding person, I would be speaking very briefly, then the author, Mr. Goutam, would speak about his book, then Vrinda would come as a discussant. The first question that I'm going to ask to the viewers is, why are we discussing Constitution? Why discussion on the Constitution is so important? And particularly why a book that has written on few judgments should be discussed at this level. For the benefit of the viewers who has no legal background, Constitution is not just any other law, it's a culmination of the culture, history, and aspirations of a nation. So therefore, obviously, the Constitution is termed as law of the laws. That is, it is the apex law, the highest law, it is a fountainhead of the legal system in a country. That's why if you look at the descriptions on the Indian Constitution, they call it as not a law, but they call it as a document, socio-economic and political document that defines the country's future. So therefore, the Constitution being supreme over all other laws, Constitution I look at in two ways. One is that Constitution as a pre-commitment. That means when we elect a government, we give all our powers delegated to the government, but on a condition that they should uphold the Constitution. Therefore, the principles that mentioned in the Constitution creates a pre-commitment for the government, whichever is in power, that they rule this country in accordance with the constitutional norms. And also, I look at the second way of looking at the government and people. The relation is that people are the principal and the government is an agent. Because we elect the government, ask the government to rule on our behalf. Therefore, Constitution is a document on which the government is supposed to rule us. Therefore, we are the principals, or we are the persons who are creating the government. The government must be controlled because it has an enormous power. The controlling is by the Constitution. Hence, Constitution is not a document for the government to restrict us. It is exactly the opposite way. Constitution is an instrument for the people to control or restrain the government. Just to give a quote of Thomas Jefferson, he says that the two enemies of the people are criminals and government. So let us tie the second down with the Constitution so that the second will not become the legalized version of the first. So therefore, why Constitution is so important is because the Constitution must make that the government is fair about the people, but not the vice versa. Hence, all the constitutional functions, whether it is a legislature, executive, judiciary, whoever it is, they have a greater responsibility of upholding the constitutional norms. And every action that taken by the executive or the legislature should govern by the basic tenets of the Constitution. In one of his judgments in government of NCT of Delhi, the present Chief Justice, that time he is a judge, he quotes that if the moral values of the Constitution were not upheld at every stage, the text of Constitution may not be enough to protect its democratic values. So in order to truly understand what constitutional morality reflects, it is necessary to answer that what the Constitution is trying to say. Therefore, either you are a judge, you are a minister, or you are a government officer, first we need to understand what are the ethos of the Constitution. And our actions should be in accordance with those constitutional ethos. However, if you look at the history of the constitutional history in India after 1950, though the Constitution created legislature and executive to bring so many social changes, but it is the court that is in forefront in bringing those changes. Whether it may be an abortion, whether it is pornography, obscenity, sexual harassment, dragging, homosexuality, you term anything, that the changes are brought not by executive by a law, but mostly it is the judgments. So therefore, if you look at from last decade, the Indian Supreme Court is constantly in the headlines, both for right and wrong reasons. We have seen the judgments of Aadhaar, privacy, Ayodhya issue, then Shabarimala, same-sex relationships, the issue of the morality in dancing girls in bars in Maharashtra, then the adultery issue, recently the same-sex marriage issue, demonetization, Kashmir issue. I can name a number of cases where the Supreme Court was in prime focus. In addition to that, the Supreme Court is also in focus for other reasons like the transparency of collegium, master of the rooster, whether the Chief Justice powers in selecting the benches. We also have seen the sexual harassment allegation, how it was handled in the Supreme Court. There are many uncomfortable questions was raised about the role of judiciary. Therefore, in this broad context, the book written by Goutam Bhatia makes a lot of sense. So he started his blog, Indian Constitutional Law and Philosophy, in 2013. In his book, he has clearly mentioned why did he write that blog. As Viraya has already raised, most of the time these constitutional laws or constitutional interpretations are debated, dissected, discussed, probably in law schools, in the courts, and maybe in legal seminars, but not in the public forum. So therefore, he wanted to demystify the constitutional law so that the non-law reader could able to understand the judgments and its impact. So his argument that the constitution judgments need to be debated in public forum holds more water than it is just simply discussing in the law colleges and legal seminars. To say that his blog is a blessing for us, particularly a teacher like me who teach constitution for several years, and also to the students, because you all know how long and lengthy the judgments are. And particularly when the judges write quotes from previous judgments, paras to the paras, I still don't understand why we need such a elaborate judgments, which makes no sense at the end of the judgment, because we can't make out what is the judge trying to say. So the moment the judgment comes, maybe in next day or 2 days, I need to comment on that in the class. I naturally go to Gautam's blog and read so that I can get a quick grasp. So you could see that sometimes he writes within few hours. I still can't believe how could he write in few hours of the judgment such a beautiful note. So I actually indebted to him in a sense that we read his blog regularly. We ask the students to read, comment, discuss on that.
This was not as a lecture.
So then the next question is, why do we need to discuss about these judgments? Because he clearly mentions that reading the judgment is not enough. Because we don't know how the judges were allotted, how the benches were formulated, what happens in the corridors of the Supreme Court, not easily, openly available to the public to watch. Though now we had some experience, some measure of the YouTube channel of the Supreme Court, we could see only the arguments, but not the intricacies of the other things. Therefore, the question is, when he has already had a blog, why he is bringing this book? He answers very well, saying that, see, blogs are written when the judgment comes, but when there are several judgments on similar issue comes in different times, bring them together in a time frame and try to understand what is the pattern. That's very, very important. So therefore, it's a commendable job that the Goutam has done on this. His book has 3 parts. The first part, he focused more on the judgments given by different high courts as well as the Supreme Court on personal liberty. Particularly his piece on UAPA, that is Unlawful Activities Prevention Act, is worth mentioning. It's really an eye-opener for us, how the court from the principle of jail to bail has come back to bail to jail now. The part 2 talks about the constitutional structures, particularly the federal structures, how the state elections where the ruling party has taken an advantage of anti-defection law. The third one, he looked into judiciary as an institution. That is, one of the very impactful argument that he makes is there are certain judgments, the cases which are very important that need to be decided was not heard in time. Maybe to give you one example, the demonetization case, which came much later. By the time, even if the Supreme Court held that it is unconstitutional, you can't do anything about it. So therefore, the judicial evasiveness, the sealed cover culture, and the role of the Chief Justice, these are all the things that matters for a common man. So in this aspect, I request Goutam to introduce his book and share his views on these judgments and how he felt. So Goutam, may I have you?
Yeah, thank you. Thank you so much. And you've summed up, I think, the core purpose of the book really well. So this is basically, I mean, the book is Unsealed Covers. And as you said, it basically arose out of a series of essays on my blog, the Indian Constitutional Law and Philosophy blog, that is now just over 10 years old. And many of these posts or essays originally began life as almost immediate reactions or responses to many of these judgments, from the Aadhaar case to the decriminalization of same-sex relations, Navtej Johar, to the privacy judgment, and to many others. And the main reason for bringing this together in a book is that over time you see that certain trends, certain patterns emerge, and then you can place similar cases together in one place. And I'll talk a bit about that in a moment. I think the other important point is that although I didn't plan it that way, the blog began in 2013, but the blog's own lifespan has coincided with the 2014 election, almost directly overlapping. And of course, what happened in 2014 was that after many years of coalition governments, many years which saw a very assertive Supreme Court that was able to take advantage of the fact that coalition governments are a little less strong than a single party government, the Supreme Court was able to carve out a very major space for itself in the public domain. So the point that Sir made earlier, which is that Supreme Court's become a larger than life institution. That's because for many years it was able to really intervene in many aspects of governance. And of course, what changed in 2014 was that after many years, you had a single party majority that came to power. And then that was returned to power in 2019 with greater numbers. And one thing that has been witnessed across the world, and this is not just India, is that wherever you have a strong executive and a dominant ruling party, that dominant ruling party and the executive always does what people call constitutional hardball, or what in India we'd call constitutional bodyline bowling, which is that you push the limits of the constitution and see what the reaction is. So you keep trying to expand your power as the government, as the executive, over the federal scheme, over citizens' rights, over everything. And you try and see what the courts will let you get away with, what they will uphold, and you keep trying to push the boundaries. And then unless you have a very strong judiciary that is willing to actually really police those boundaries and preserve the integrity of other institutions like the Election Commission and so on, these attempts are successful. So you need a very strong judiciary to push back against that. And one thing that we have seen, and one thing that the book covers, is how that dynamic has played out over the last 10 years, the last decade, that we've seen a very strong executive at the center that has been trying to really advance its own understanding of its power and the constitution, that often runs up against the established understanding, and then you see to what extent it can push that view. So with that introduction, what I'll do is, in the time I have, I'll take one specific issue, which is the UAPA. I'll talk a bit about that, and then I'll make 3 points about the Supreme Court as an institution. I think that's something that is a little opaque, because it's such a you really have to be in the Supreme Court to understand a lot of what goes on over there. And because I've been practicing for a while now, it is something you end up seeing just walking in the corridors and being inside the courtrooms on a frequent basis. So on the UAPA, and so the UAPA, I devote a lot of time to the UAPA in the book. The first part of the book is about the UAPA. And the reason for this, of course, is that we all know that there are many political prisoners in Indian jails who are there because of this law, the Unlawful Activities Prevention Act, the UAPA. Now, the key legal provision is something called Section 43, Clause D, Subclause 5 of the UAPA. And I wouldn't go into technical language. I'll just, in simple terms, it basically says that if when you apply for bail under the if you're accused under the UAPA, you apply for bail as an accused. If the judge believes that there is a prima facie case, which means on the face of it, there is a case against you, or if there are no reasonable grounds for thinking you're innocent, then the judge cannot give you bail. The law bars the judge from giving you bail. In a sense, the language is a little different, but that's what it basically means. What it means in practice then is that at the stage of bail, the only material the judge will have is the charge sheet or the police version. So the judge will have before them the police version of the event, the FIR, the charge sheet. At the bail stage, you cannot, as the accused, bring your own evidence forward, your own defense forward, because that will happen at the trial stage. At the trial stage, you will examine the witnesses, all of that, but that will go on for 10, 12, 15 years. So that, is going to take a very long time. So at the bail stage, the only material before the judge is the police charge sheet. And so when the UAPA says that on the basis of the materials before the judge, if there is a prima facie case, that makes the judge believe, that the person may be guilty, then they can't give bail. So effectively, it's a very one-sided proceeding because all the defense can say at this stage is to try and point out some internal inconsistency in the police version. Say that, look, this is clearly a false fact, or this doesn't add up. Even if this is true, it doesn't make up the offense. So this is a very limited range of things the defense can say. And I've, in my blog and in the book, compared it to if you're swimming with one hand tied behind your back. Right? So defense is like you're swimming in a pool or in the sea, and one arm is tied behind your back, and you try and swim with like one arm. That's what the defense's position is in a UAPA bail case. Now, that's what the law says. Now, of course, one option is that the court will strike down that law as being unconstitutional. But our courts have never done that for criminal laws. It's almost never happened. So that, is something you really can't count on. So then the question is that now you have this law in front of you. What should a court do that on the one hand has this law, on the other hand has the Constitution, which talks about right to life, due process, free speech, all of that. So how does the court reconcile these two documents, the UAPA and the Constitution? And what you see over the course of the last 5-6 years, and this is what I cover in the book, you see two lines of cases or two strands of judicial thought. One, let's call the pro-liberty or the pro-due process thought, and the other is the pro-state or the pro-executive thought. Now, the due process thought, there are two ideas underlying that. One is the idea that, look, this is a very draconian law. You will be in jail for many, many years pending your trial. The punishments are extreme. Therefore, the court's job is to interpret this law in the narrowest way possible and stringently enforce the safeguards, given the extent of punishment, given the draconian nature of it. So what does the court do? The court, on the one hand, gives the substantive provisions of the UAPA, like terrorist offense, a narrow reading. So, for example, not every public order offense is terrorism. Right? So if you just say that, look, there was a chakka jam, or a blocking of a highway, that is not terrorism. That is maybe at best a public order offense. And therefore, if the police version establishes at the highest, taken as true, that you, the accused person, called for a chakka jam and a blocking of highway, then that is not a UAPA offense. Because even if it is true, it is at best a public order offense. That's one argument that this line of judicial thought makes. And the other argument is that every fact that has to be established to prove the offense has to be there in the police report. So, for example, if the allegation if the allegation is that you, the accused, effectively conspired to cause riots, and that is the offense, then the police have to, at least in the charge sheet, show, okay, who was this conspiracy with? Show that actually there was some actual meeting between these people, and there's some evidence that they were actually planning this to happen, and prove, at least have all of that in the charge sheet to establish the offense. What always happens in these charge sheets is that there will be these big gaps in the police version, and the police will say the conspirators are so smart that they themselves made sure that there would be no evidence, and therefore we can't have evidence. And that shows actually how smart they are, and therefore it shows their conspiracy. So, for example, in this case involving Umar Khalid, whom all of you know of, the evidence that the police had to in his UAPA case, for example, is that the riots happened, and immediately after that there were a number of phone calls made between the accused and other people. And that shows conspiracy. Now, if you think about it, if you are an activist, and riots are happening in your neighborhood, the most logical thing is that you would make phone calls to other people saying, what is happening? Let's try and, bring peace or make sure that the riots don't spread. The police has no evidence that those phone calls were meant to, intensify the riots. They just say, look, there are these phone calls and this is suspicious. This shows conspiracy. And they invite the court to then fill in these gaps and infer that there is conspiracy. And so this pro-liberty line of cases says that the court will not do that. So unless the police shows that every fact in the chain is there in the charge sheet, the court will not fill in the blanks and introduce conspiracy where there is no evidence of it. So these two arguments the court makes, and in that way, in some cases under the UAPA, bail has been given despite Section 43 clauses, subclause 5. So, for example, in this case involving Asif Iqbal Tana, which was decided by the Delhi High Court 2 years ago, this was the analysis the court gave. That look, you, the police, at least in your charge sheet, have to show that the facts are there. Otherwise, we the court will not fill those facts in for you. So that's one line of cases. The other line is the opposite. Where the court, one gives a very wide interpretation to the offenses of the UAPA. So everything then becomes terrorism. Any kind of public order offense becomes terrorism. And the second is that the court does the fill in the blanks. So if the police version has certain gaps, the court will say, look, you can't expect the police to prove everything at this stage, but enough has been shown to actually show that there is some indication of conspiracy, and therefore we accept the police case. So in Umar Khalid's case, for example, this is what happened. The court used the fact of there having been phone calls to say, okay, this shows some kind of meeting of minds to conspire without any other proof. There was also this case involving Safura Zargar maybe 2.5-3 years ago, where actually the individual accused was not even at the place where the riots happened. She was somewhere else. There was no proof that she gave any kind of incendiary speech. But the court says, effectively, the court uses this phrase. The court says, if you fan the fire, then the embers might spread anywhere. So you can't then blame the embers for going anywhere. Now that, of course, that's not legal reasoning, because that if you fan the fires, literally anything can go anywhere. So there is no sense of a real clear causal link between that. So the upshot being, and this is what I discussed, the Constitution is basically this terrain of contestation, or it's like a battlefield between these two versions. One is of the pro-constitutional, pro-liberty, pro-due process version, and the other is this pro-state, pro-executive, pro-police version. And you have courts going both ways, and in fact, sometimes even the same judge will write judgments going both ways. It's very surprising. The same individual will give two judgments going the opposite way. One judgment will have the first view, and the other will have the second view. But I think what that shows is that, therefore, if you're lawyers, or if you're citizens, it's really important to keep trying to push for the constitutional reading, because we do have judges, we do have lawyers who argue for that, and judges who still decide cases on that basis. And so at any time, our responsibility then is to try and really, in whatever way we can, in the courtroom or outside, to keep advocating for due process, for the rights of the accused, and for ensuring that people don't spend so much time in jail without any trial. I think that if you look at the issues covered in the book, the UAP as one, you always see this contest happening between the pro due process, pro liberty, pro rights, and the anti rights. It's never that every judgment is against rights, or every judge is going to give a pro state judgment. You will always have a little bit of push and pull happening. So our responsibility then is to try and really support the correct and the progressive reading of the Constitution. So that's the first thing I will say. The second part is these 3 points about the Supreme Court. I think it's very important because right now the Supreme Court effectively is both the first and the final court in any important constitutional matter. It's always the Supreme Court that really hears these cases. So I think that the first thing to really understand about the Supreme Court is that the Supreme Court has 34 judges, but the Supreme Court effectively right now is the Supreme Court of the Chief Justice of India, whoever the incumbent is. It's not about a specific individual. And that's because of something called Master of the Roster. Now, what is this Master of the Roster? Basically, when these multi-panel courts evolved in England in the 18th, 19th century, there were many judges. There had to be one judge who would effectively administer the court. So you had to have one judge whose responsibility was to supervise, the administration, and that was the Master of the Roster, or the Chief Justice. So effectively, it was that your role is to administer the court, to make sure everything is in order, and just take care of the court's business. Now, what has happened in India presently is that one power of Master of Roster is to assign cases to benches. Now, this is okay in a court, say like the South African Constitutional Court, for example, where you have 11 judges and 9 judges sit. So that it's okay. In the UK Supreme Court, you have 15 judges and 5 sit. So out of 15, you give it to 5. It's okay in a case like that. The problem in India is that we have 34 judges, and you have 2 panels of 2 judges each. Out of 34, you can pick any 2. Now, this is a big issue, and the reason for this is that there is one thing that our Supreme Court is very hesitant to admit, but it is something that is true for all courts everywhere, and there's nothing wrong with it, which is that judicial ideology is a thing. It exists. So some judges are reflectively pro-executive. That's the way it is. It's always the case. It has been the case everywhere. This is not something special to us. You look at the US, same thing. Look at the UK, same thing. Look at India, same thing. Some judges are reflective pro-liberty of so your pro-state judge will give much more leeway to the state, will defer to the state, where the pro-individual judge will, be much more skeptical of the state's power. And as I said, this is something that is very common. It is inevitable. Any judge comes with a whole history, a whole baggage of ideas and ideologies. As lawyers, we have those ideologies, and if we go to the bench, we don't want to leave them behind. We still have those. But then the problem is that when you have a court of 34 judges, out of which, say, 7 or 8 in UAPA bail matters are pro-state, 7 or 8 are pro-individual, and the rest of them don't really have a strong view one way or the other. And let's say that's the composition of the court. The Chief Justice's ability to pick the bench effectively is then you have the power to decide a case. Because if you send it to one of the 7 or 8 judges who are pro-state, then bail will not be given in all likelihood. Because Supreme Court, always you can say, look, why should we interfere? High Court has decided. If you give it to the pro-liberty judge, then they'll find a reason to say, look, this is obviously not. This is a problem. Many years in jail have passed. Evidence is not enough. So, as I said, like you effectively, when you assign the case in a matter like the UAPA, in these really crucial cases, Article 370, no individual who has been involved with the law or a judge will not come to 370 case without a preconceived idea about rights or wrongs of it. All of us have a view on 370, right? We've always had a view on 370. Similarly, same-sex marriage. We all have a view on it. And so the power of Chief Justice to pick the bench is actually a power to decide the case subject to some shock or, something extraordinary happen. So that's the first problem. And there are many solutions, that have been offered to this in various countries. But in our situation right now, there is no solution that has been offered because since 2017, there has been this judgment that says that nobody can question the power of Chief Justice to assign a case. And that, of course, leads to all these problems. So I think that's the first thing. You to understand that our Supreme Court is effectively the Chief Justice of the Supreme Court. So whoever it is, and there's a big problem because as is a common argument for any institution, that no institution should have a single point of failure. Right? So one person should never have this much power in any institution because then the institution rises or falls with one person, and that's always an institutional weakness. So that's point one. Point two is sealed cover. So the book's title is Unsealed Covers, and that's a play on the fact that the last few years, the court has been taking evidence in sealed covers. And this is really antithetical to any kind of open justice because the legitimacy of the court comes from its reasoning. So when the court gives a judgment, we accept the judgment not because of the outcome, but because the court has applied the law to the facts, and how it's done that is evident in the judgment. It shows us how by showing us the reasoning. So we may disagree with the reasoning as citizens, but we accept it because that is what the court's job is, to give reasons. Now, for that, what has to happen is that the material on the basis of which the court has given its reasoning must be open for all of us to assess. Otherwise, we don't know on what basis the court's judgment is coming. And so when in all these cases, in like the Rafale case and other cases, I think also demonetization, also there was the sealed cover evidence. When the court takes evidence in sealed cover and then gives a judgment in favor of the executive, there is no way of actually being able to assess the court's reasoning. Was it right? Was it wrong? Was it strong reasoning, weak reasoning? You can't tell. I think even in this Adani Hindenburg case, there was evidence taken in sealed cover. So that's one big issue. And it's even worse when the other side's lawyers are not given the sealed cover. And I saw this again in the UAPA case in the Delhi High Court a few years ago. There was a banned organization. So the UAPA, you can ban organizations. And then the High Court is the tribunal. You go to the High Court to challenge that ban. The High Court has to, confirm that ban. So there was a High Court hearing about the organization which was banned. And one crucial piece of evidence was the register of members of the organization. On the basis of which they were saying that these members have had FIRs against them, and therefore it just shows that the organization is full of people who are criminals. And that register of members was basically submitted in a sealed cover to the court, and the defense counsel wasn't given a copy. So the basis on which you banned the organization's lawyer was not given copy of the evidence. So on what basis is he or she going to defend their client if they don't have the facts on which their client has gotten banned and their constitutional rights have been restricted? So you see this happening a lot in Supreme Court and in the High Court, where they take this seal cover evidence and they don't. The public can't see it, so the public can't really assess the judgment. And sometimes even the lawyers can't see it, so they can't even defend or represent their client's interests. Now, the origins of sealed cover basically were, for example, if there is some commercially private information, some stocks and shares. If I reveal that to the public, then the stock prices, will go up or down. So, until the case is concluded, you keep that in a sealed cover. Or if there is an election and you have challenged the election results are in sealed cover until the court decides the election case. That's another example. Things like that. So very narrowly focused, issues which have now expanded into this whole, jurisprudence of sealed cover, where the court frequently takes evidence in a sealed cover and nobody can see it. That's the second really big problem with the way the Supreme Court functions right now. And the final issue is judicial evasion, which is something mentioned before, which is that you have a really crucial constitutional case. The Supreme Court will not hear the case for many, many years until basically it has become irreversible. The facts have become irreversible. And so by not deciding the case, the court decides in favor of the government. So demonetization was one case, 5 or 6 years it took to hear the case. 370, it took 4 years. The Delhi case, it took around 5 or 6 years for a judgment to come. In 10 days, the government passed an ordinance reversing that, and that silence has not been heard yet. It's almost been one year now. In the Maharashtra case, which was 2 years ago, they passed an interim order with respect to the governor and the speaker's roles. And then when it was said that either decide the case now or don't pass the interim order, because once things happen, you can't turn the clock back. In the Maharashtra government case, the Supreme Court said in June of 2022 that don't worry, we are here. If required, we'll turn the clock back. And then 1 year later, they said, now we can't turn the clock back. So too bad, like everything was done wrongly, but we can't turn the clock back now. So this is, in a certain sense, we've seen this happen over the last 5 or 6 years, where there are cases where where either you decide the case at the time or any delay means that the status quo benefits the executive. And the one argument is the Supreme Court is, overburdened and there are many, many cases, which is fine. But then one thing, for example, and I've been recently following the Supreme Court of Kenya very closely, when they have a constitutional challenge, and if there is a very complex set of issues involved, which they need some time to decide, they always have a hearing on the stay of that law. So they will, within 1 week, grant a hearing on the issue of whether the law should be stayed. Then both sides will come. There will be a proper adversarial argument on stay, and often the court will grant the stay. So it's not just that the law continues until the court decides, but if the petitioners can make out ground for a stay, the court will grant a stay. In fact, the High Court last year actually stayed the Finance Act in Kenya, which was later lifted by the Court of Appeal, but they don't hesitate to stay laws if they know that it will take some time to decide the case finally. Whereas in India, that doesn't happen anymore. So in any of these constitutional cases, first thing, the court will never give a stay. They won't even have a proper hearing on stay. And B, they will take 6 years to decide it. So then effectively, when you combine these two things, it's a free pass to the government. So I think these three things, judicial evasion and the sealed cover and this master of roster, are these three defining features of the Supreme Court over the last 5-6 years, which together, if you look at it, really allows the executive to get away with a lot of things that should be scrutinized in much more detail and much more rigorously by a constitutional court. So that's the discussion in the final part of the book, and I'll close with that. These two things I want to communicate, And of course, the rest of the arguments and the posts are in the book, and it's written for a non-legal audience. So the idea is that, even if you're not a lawyer, you should be able to follow it and understand the arguments. So I hope that, you enjoy the book, and thanks again for inviting me onto this show. Thank you.
Thank you, Goutam, for such a wonderful presentation, and you have really captured the book. So without wasting my time, because Vrinda has another engagement. So Vrinda, can we have your comments on?
Thank you, Professor Prasad, and thank you, Goutam. Thank you for writing this book and for your blog, as I'm sure many have told you before this. I think it's a very important contribution that Goutam makes by writing articles, as Professor Prasad and many others have always said, very promptly and with clarity and precision about the judgment, where he deals with what has been said in the judgment, what the law says, how perhaps the Constitution interpreted these issues, and makes it available for all of us at large. And some of those he has now put together in this book for us to see. When it comes together as a book, it's easier to see the trends that are emerging in the Supreme Court. Although I wonder whether the last few months, if I'm not wrong, perhaps you stopped at 2022 in the book. And perhaps the last year of 2023 has actually been, so much has happened that maybe that graph needs alteration and is peaking at certain points and going off the charts literally. So perhaps you should not be waiting for 10 years to put your articles together. You may be required to do them with greater urgency, which the court is actually provoking you to do. I also think it's and I think we need to note this, I think it's very courageous of Goutam to do this, because he's now a practicing lawyer in the very same court. Lawyers are mostly very deferential to the court, because I remember hearing this from when I was a young practicing lawyer, that, that's the only way you will get relief from the court. A, I don't think that's true. And B, I don't think that's how a lawyer should practice. So I think the fact that he practices in the same court and yet is very, is making his comments, his criticism, his critique so openly and publicly is something that, particularly today, when more and more people are reticent in speaking and at least in commenting, and all forms of comment is today seen as almost treason, I think it's very remarkable that he continues to persist in writing. And I think I don't think it's in his control. I think he's just has to do this for himself more than anything else, which is very good. Having said that, the structure of the book has been put forward both by Professor Prasad and Goutam, so I'm not going to go into that. But before I'll respond to some of the things that Goutam has said and then comment on a few. But before I do that, I want to particularly thank him and commend him for something that he has done for long in his blog, was the editorial note he gave on any judgment delivered by the then Chief Justice Ranjan Gogoi, where he spoke about the indivisibility of rights and the fact that a Supreme Court woman staffer was never given even procedural opportunity and justice to be able to get any kind of, against her complaint of sexual harassment by a sitting Chief Justice of India. I think it was absolutely, I cannot tell you how heartening it was to see that editorial note, not just once, but repeatedly as long as Ranjan Gogoi was the Chief Justice. And as a disclaimer, I was the counsel for the Supreme Court staffer, and it meant a lot that this issue was taken seriously as an issue of procedural justice, as an issue of natural justice, as an issue that the institution needs to reckon with, which very often, and we know that women's rights are treated as, those little things that some people dabble in. Actually, it speaks to the heart of the power that is entrenched not only in the Supreme Court, but in the Chief Justice of India, and remains an institutional gap that the Supreme Court of India does not address. In fact, if I may just share here, when a petition was filed, and I've represented both the interns who had made complaints of sexual harassment against two different Supreme Court judges. When the petition was filed on behalf of the second intern, we also filed a petition which we colloquially call Vishakha Part 2, as some of the petitioners were the same, saying that there continues to remain a gap in the redressal mechanism when it comes to sitting judges and former judges of the Supreme Court of India. Amongst the many cases, Goutam, that never get a hearing is that petition languishing in the registry somewhere, which of course the Supreme Court has not considered an urgent matter to address. I will first just respond to some of the things that Goutam said, and then I'll comment not necessarily in terms of saying what the book says, but rather to take some of the ideas forward. I think there was an important remark that Goutam made about having a judicial ideology. And yes, we all have. I firmly believe that there is no such thing called neutrality. It's a myth. Nobody is neutral, including the state. The state is never neutral. So yes, there is judicial ideology, and it comes with democracy. But I think there are two things that one will need to factor in over there. One is that there is also constitutional ideology. So at the time of appointment of judges, if a judge's ideology is at variance with the constitutional ideology, does that judge merit an appointment? I am not saying that there will not be polyvocality. There will and there must be. But having an ideology that is at variance with the Constitution, to my mind, constitutes a factor why somebody need not be appointed, at least to the highest court of the land. Secondly, I think when I read your book, Goutam, is that I have never seen such a good case being made out, and you feel this acutely when you read the book, for diversity on the bench. And by diversity on the bench, I mean diversity not only from how many high courts are represented, how many states are represented, but diversity of experiences, diversity of ways of living. The judgments that we get today, say on demolitions, the judgments that we get on what is happening to workers' rights, are coming out of a space where there is absolutely no comprehension. There is no imagination of what is the life of the other. And we have no way of even dealing with that. The only conversation that happens here is, oh, you want reservations. One is not talking about reservations. One is talking about diversity of life experiences. And that is the one good reason why one talks about why there should be women on the bench, or persons of different sexual orientation, gender identity on the bench. Similarly, there are people who, a very large majority of people, who actually live a very different life, of which there is no comprehension whatsoever. And, when you hear, I think the live streaming is actually making that more and more clear. Just to go back to a case that was being argued very recently, the Section 6A was being of people of, what is migration? Who are these people who are coming in? What is the role of the state? It was so obvious that some of those questions that were being asked both by the bench and responded to, there were certain worldviews and understandings and insights that were totally missing from the court in the kind of exchange that was taking place. And definitely, the state was not contributing to any of that. So I think we need to start talking a little bit more about this, particularly at a time where the state is not just wanting, and Goutam very rightly pointed out that 2014 marks a majoritarian state with a brute majority in parliament, and therefore you're dealing with a legislature and executive that is very powerful, but which is today not only bullying its way, but is a defiant state. The Supreme Court can pass a judgment and a law will be passed overturning the selection committee of the Election Commission of India. So there is a defiance that the state has towards rule of law, not only in its executive action, but in its response to Supreme Court judgments. So if that is the nature of the state, then how is the court then to engage? How is particularly the Supreme Court of India to engage with that? What one again finds coming through a thread in reading Gautam's book is the utterly deep and abiding faith the court has in the state, and which the state actually doesn't necessarily have to demonstrate. It is a given. And if the state has said something, then there is a faith that is done in good faith. There is no evidence to that effect anymore. In fact, there is a lot of material and evidence to the contrary. But somehow there is a suspicion of the citizen, which is reflected in the way the court is responding to what the state is saying. And simply because the state says so, it seems to satisfy the court. And whether the court, which recognizes itself at the same time, the Supreme Court recognizes itself as the one organ in the democracy that is going to put some restraint. But if that court works with saying everything the state says and does is bona fide, then how does the court respond to that? And when I read the book, Gautam, what it provokes me to think is two things actually. One is that it is, and somewhere it goes back to the diversity of experiences. That these are and I'm saying people are doing this in good faith. I'm actually not attributing any bad faith to anybody who's on the bench. They believe that that state power must be maintained in this way. They believe that the state will do things that are good for everyone, regardless of the fact that the state may come to court during COVID and say there is no migrant and there's no hungry person on the road and no intervention of the Supreme Court is required. Although a sitting judge of the Supreme Court is actually distributing relief on the highway because the situation is so poignant that anybody with a shred of humanity is moved to what is happening. But the court still takes this in good faith, and it takes a lot more to actually move the court. So with this kind of good faith underlying the manner in which the court is going to respond, how does one then assess it as the only institutional restraint that we can have in a democracy? I'll just quickly turn to a couple of things that I wanted to comment on. And I think Gautam spoke at length on UAPA. I only want to refer to, while this book looks largely at Supreme Courts and a little bit at the High Court, I think there is a very interesting judgment that has come from Jammu and Kashmir High Court recently in November of 2023 in the Fahad Shah case, where Fahad Shah is an editor of a blog called Kashmir Wala, and he was arrested in multiple cases, including under UAPA, along saying that you 11 years ago published an article. And of course, it's the same story about how this is to create an anti-India narrative, etc., etc. And that one article was going to create, secessionism, etc. The High Court writes a very interesting judgment where it asks itself two pertinent questions. That how do we look at UAPA? Is there a need to arrest And is there an imminent danger for this person to be kept behind bars? And they engage with the Vatali judgment and work around it. And I think each time the constitutional courts or any court has dealt with 43D5 of UAPA by going back to the constitutional questions, they have found the answers around the embargo placed by UAPA, whether it was in the Anand Teltumbre case by Bombay High Court or Arun Ferreira and Vernon Gonsalves by the Supreme Court, and again the Fahad Shah judgment, which makes for a very important and interesting reading. Similarly, you refer to briefly to the Mia Qayyum case. And I'm referring to these cases because I personally, as a lawyer, I've been involved in some of these cases. And Mia Qayyum's case, actually, the High Court judgment is Mia Qayyum was the president of the Kashmir Bar Association, and in 2019 was held in preventive detention. The High Court did not strike down the preventive detention by saying that ideology is like a live volcano. And therefore, the fact that he was arrested in some case far too long ago, the proximity test and the causal link will not apply because this ideology is inherently like a live volcano, actually leaving no room for that person to ever exit. And the only thing that was offered by the state was that he should publicly declare that he will shun this ideology. So it is not just about what you do, but what you think is what the courts are now actually seeking out. In the Supreme Court, he was given relief and he was released. Only condition that was put was, and as I said, I was personally involved in this case, and the court did ask us the same question, whether he will say that he shuns this ideology. And we said we would not be asking this question. And then the court said, all right, the anniversary of 2019 abrogation of 370 is coming. So just for those few days, he should not go back to Srinagar till then. And of course, he was being detained in Tihar jail under preventive detention. So what is important here is that when you go back to the Constitution, that you do get the right answers to cross the hurdles imposed by the anti-terror laws. And at the same time, when you what is it that the anti-terror laws are today trying to target, whether it is, as was referred to, the Umar Khalid case or many others in the Bhima Koregaon case? None of them have any overt act being attributed even by the state. It is what you are thinking, what you are saying, and actually if we were to see the new Bharatiya Nyaya Samhita, those have been made offenses already. I'm going to be running out of time, so I'm just going to quickly go to one other aspect, which is the case that was mentioned again in one of the chapters. You talk about the Gymkhana Club case, which actually was then the whole episode in a sense repeated itself, and in the Delhi Golf Club, a woman dressed in a Khasi attire was asked to leave, and the employee of Delhi Golf Club said she should leave the dining area because she looks like a maid, because she was obviously had features from the Khasi, and she belongs to the Khasi tribe. That's again a case that I was doing, and we've recently, the case has got concluded. And the Delhi Golf Club, which of course receives land at very, very concessional rates from the state. Interestingly, the court declined to go into those aspects, and however accepted the Article 15(2) argument of this being a place of public resort or public entertainment, and therefore there can be no discrimination on prohibited grounds. And the Delhi Golf Club has now, during the course of the hearing, amended its bylaws, which interestingly earlier, and this is really so deeply colonial, which earlier said that members' domestic employees cannot sit in certain demarcated areas. In the course of the hearing, the golf club has amended its bylaws. However, the court refused to look into it as a state subsidized land issue so that there could be wider ramifications across the board, not just for Delhi Golf Club, but for clubs across the country. The court did not wish to entertain and take it further down there, but just deal with the immediate, which, as we know, courts often don't want to take things beyond what is before them. I will just end with saying a very important thing that Goutam pointed out with respect to the comparison with the Kenya Constitutional Court about no state. One example that stares us in the face is the challenge to the constitutionality of the anti-conversion laws, which go under the garb of freedom of religion. Now, under the anti-conversion laws, which there are a slew of them, about 10 or 11 of them now, which have been challenged, the Supreme Court has called to itself all the challenges from the different high courts. People get arrested even now. And in UP, that law is operative. In many other parts of the country, the law is operative. And it's a very, very reckless law, which gives a very wide amplitude to a range of people to actually file complaints, interfere in people's personal lives, and seek arrest. Those laws they are neither being heard, nor is there a stay on its operation, seriously jeopardizing personal liberty of very ordinary persons. Now, on the one hand, the Supreme Court upholds repeatedly people's right to make their own choice in partners, etc., etc. But when the state wants to interfere and target certain groups and communities for making choices, we see that the court has not jumped in. And I think in terms of learning from others, yes, bringing in technology, bringing those changes, it has its advantages. But I think much more serious reflection needs to be made by the Supreme Court as an institution to what can be the learnings for ensuring that people's liberties and rights are not jeopardized. And there, perhaps things can be learned from Kenya or any other jurisdiction. And I will end here only with saying thank you very much. Goutam, please keep writing. I know the times are not the best for any of us to be airing our views, but I think we need to keep saying these things and speaking. So thank you very much.
Thank you, Vrinda, for such an excellent discussion, taking further from what Goutam has written. Just to say to sum up what has come up. One is that we are continuously looking at the cases and identifying the patterns in which the judges are deciding. And this is very important because probably from 2017-18 is a starting point of the new doctrine in the Constitution called constitutional morality that is emerging. And if you see in some judgments, the court is very clear that the constitutional morality should prevail over social morality. So in that sense, where Vrinda has raised the issue, what if the judge's idea is, judge's ideology or judge's personal opinion is against the constitutional ideology? Can that person be a judge? I would take it further to a constitutional functionary, whether a prime minister, chief minister, ministers, and MLAs. If their personal, say for example, their personal belief is not to have a secularism, but that once they were elected, the constitution promotes secularism, whether they should bound by that or whether they should bound by their own personal agenda. So I think that conflict would come, particularly when they are deciding the constitutional matters, because constitution is what the judges say. We have reached to that point. Though constitutional texts are there, ultimately constitutional interpretation is in the hands of the high courts and then finally the Supreme Court. So if you look at that sense, what constitution is what probably 5 or 6 judges decides every time that the narration changes. As Goutam pointed out, that is the fallacy, or that is the thing that we have to live with, because every country has the same. Even the American Constitution, the American Supreme Court recently, we have seen how they are gone back on the abortion rights. It all depends on the ideology of the judges. So that is one issue. The second one that he pointed out is that the stronger the government, the possibly may impact the strength of the court. That means if the government is too strong, could the court become weak? Maybe sometimes yes, but sometimes not, because we have seen during Indira Gandhi time how the tussle between the court and the parliament continued. We have seen 24th, 25th, 26th amendments, particularly with the basic structure. Then the other important thing when he is talking about the judicial evasion or judiciary not ready to decide the cases. Also, I come to the latest case in the Supreme Court when it comes from Andhra Pradesh, the Chief Minister, the former Chief Minister Chandrababu Naidu was arrested. Then the question of interpretation of Section 17A of the Anti-Corruption Act, whether the sanction is required. I think it is still pending. Even though arguments are over, everything is over, we don't know when the judgment is going to come.
The arguments were put at the end of October. It's been pending for months.
Exactly.
17,
and we are almost like 4-5 months, nothing happened. So we don't know why, what is the reason. So that's one problem. Therefore, the question is whether the collegium system invented by the Supreme Court to protect itself has created a better judges now, or before the collegium, the judges are better. Whether the ability of the Supreme Court to stay independent from the executive is achieved through this collegium system or not is a debatable issue. I think this is the only country where the judges can appoint themselves, right? Then, as Vrinda has identified that Goutam is writing, even though he is a lawyer. In fact, what he is doing is supposed to be done by us, like teachers, who are less prone to the problem of the court. But unfortunately, now the teachers have become more like an administrators rather than the teaching with all other activities that they do. So there is less research. So I hope he will still continue to write. Then the question of that, I'm going back to the ideology of the judges. Are the judges in ivory towers? That's the question that we need to seriously answer, because particularly when she raised the issue of the migrant workers issue, I think it is completely insensitive for the court to decide that matter in such a manner. Probably the judges are not exposed to that. Then the issue of UAPA, it reminds me the TADA, the old act. How ultimately the TADA was diluted, then finally it was removed. Probably it all depends on the next election, how strong the next government would be. If, as Goutam identifies, that the stronger the government, then from the government is going as a different government, as Vrinda identifies. So therefore, I think when we say that we don't like politics, but our whole life is in politics. So the judges, the decisions, everything is politics. That's why we need to really look into these judgments, have a debate, have a consensus. But at the same time, when you have these debates, would we be arrested under UAPA? That is a question that is looming on our head. So thank you very much for all of you for giving such a wonderful talk. I just make myself correction. I mentioned it is Telugu Adda. I'm sorry, that is it is Manchi Pusthakam and Ailu Telangana committee, because I was associated with Viraya with Telugu Adda. I took his name. So thank you, Viraya Garu, for giving such an opportunity. Over to you.
Yeah, before closing the session, I want to invite. Is Goutam there? Yeah. So, coming to the bail provisions of UAPA, about 20 years back, there was a discussion in the parliament in terms of POTA. The act was presented before the parliament in the wake of attack on the Bombay. There, the whole parliamentarians spoke on the provision of putting the onus on the accused to prove himself not guilty. That was the condition. Ultimately, during about the period of time with the span of elections, the new government came in and the act was pushed under the carpet. Again, the state reworked over the 20 years and brought the same provision in the different gobs of law. So how that particular provision has traveled over the period of time in terms of judicial interpretation?
This is actually much older. This actually originally comes from 1920, the 1920 colonial British law. This specific bail provision, this sort of language is there in 1920, and then it sort of comes in the Defense of India Act in during World War II in 1941-42. It's meant to be only a wartime measure, but then after the war ends and then the independence happens, it's then taken up into various Defense of India Acts that are then passed after independence. Defense of India Act after 1947, then Indira Gandhi 1971, the MISA, Mechanism Internal Security Act, MISA 1972, then TADA, and then POTA. So this is been there almost consistently from 1920. It's not new. This specific thing of having to prove that you are not reasonable likelihood of not being guilty at the bail stage. This is what they call the twin test. The twin test that's been there for like 100 plus years now.
So one more thing, you almost came close to defining the executive code.
Yeah.
Kanvilkar's legacy and dealing with Kanvilkar's legacy.
Yeah.
So what was your idea of being executive code? Okay, there are some, because I am asking this question as most of the viewers are legally acquainted people, so it is better to explain a little on that.
Yeah, so I mean, there's classic thing called separation of powers, which is the legislature, the executive, and the court. So the idea is that each of these organs checks the other two organs from not overstaying their sort of jurisdiction. And because of these three organs as checks and balances, there cannot be concentration of power in one body. That's the idea. That's why you have these three different wings of state. And also, of course, the language and the vocabulary is very different. So legislature, is meant to deliberate and pass laws. Executive is meant to implement. So efficiency, all of that is the executive vocabulary. And the court's vocabulary is rule of law, due process, all of that. So that's supposed to be how it works. When I say executive court, which has been again happening over the last few years, is when effectively the language of the court becomes indistinguishable from the executive. So how it decides cases, becomes indistinguishable from the executive. So, for example, if you look at the judgment of Justice Khanvilkar, which upheld the FCRA, the NGO funding law. So he says things like, why do Indians want foreign funding? They should be, energetic and strong and get their own money from local sources. Why is there dependency on foreign funding? Things like that. So there's what the court is meant to actually apply the constitution. So, is the FCRA a reasonable restriction on the right to free association? Does it meet the constitutional tests? And it's not the court's concern. Is this, law good, bad? Is the motivation good, bad? Should there be that's not the court's concern. It is to test the law. So the court has stopped doing that, and it just sort of now makes these statements that are sort of indistinguishable from what the executive says. And it sort of then becomes a body that is not so much as testing executive action for constitutional compliance, but validating executive action. So that's sort of its role, and that sort of makes it the executive court. I think that the key distinction is that under previous chief justices, a lot of the executive court was happening through evasion or not hearing cases, and sort of in that sense, enabling executive action to go unchallenged. I think with the present chief justice, last 1 year or so, you actually have sort of the executive court appearing as a doctrinal or a jurisprudential concept, right? So, for example, in the Article 370 case, when the question comes of the degradation of the state of J&K to a union territory, the court in its judgment says that we're not deciding this case because the state has given an assurance, the executive through its law officer has given an assurance that they will at some point in the future restored the status of J&K to statehood. Now, what was happening until now was that if the state's law officer made an assurance, the court would postpone the hearing. It would not hear the case. It would sort of football the case. So this executive court thing, where the court and the executive are acting together, was happening, but was happening sort of on an interim order basis. But now with the present Chief Justice, that's become a part of constitutional law. So the assurance given by the executive through its law officer is a legal reason then for the court to not decide the case against the executive. So I think that's the key difference. Now we have the executive court, which also in its judgments and not just sort of in these interim orders. So that's the, I think, big change over the last few months, perhaps.
I think. Thank you, Goutam. As at the time of CA debate, one law professor wrote that there is no point in looking at Supreme Court. Even Supreme Court is also part of the institution of the state. So to protect the Constitution, only people have to move around, come out in the public to assert their rights, what is guaranteed in the Constitution, and how they are being diluted or from time to time. So with that, this book will be a great contribution towards inculcating an idea of asserting their rights by the public, for the public, and of the public. So with these words, I thank once again both Goutam and Rundaji, and also I especially thank my friend and professor Prasad Garu. And one more request, Mr. Bhatia, as you mentioned yourself that it is meant for non-legal audience. So do you have any ideas to translate this book into various other languages? If that is an idea, we are ready to have some collaboration with the Telugu publication.
Yeah, I would love that to happen. So if you can drop me an email, then I can talk to my publisher and they'll get in touch with whoever is willing to do it.
Yeah, most of our publications are kind of non-profit organizations. So keeping that in mind. Yeah. Thank you. I'll come back to you to discuss on the transformative constitution aspect.
Thanks. Thank you.
Thank you.
Thank you, Vrindaji. Thank you.
Thank you, Vrinda. Thank you so much.
Thanks, sir.
Aspect.
Thanks. Thank you.
Thank you.
Thank you, Vrindaji. Thank you.
Thank you, Vrinda. Thank you.